Good afternoon, and welcome to Pay Entry's weekly webinar. Today, we'll be providing you with information about pay equity. What is pay equity and why should you care? I'll be presenting today. My name is Kathy Graham, and I'm head of HR services here at Pay Entry, and I want to welcome all of you today. First thing, I want to just remind everyone that I am not an attorney and that the information that we present in these webinars weekly are for educational purposes only. They do not and should not be construed as legal advice from us. So let's get started. So what is pay equity and why should you care? We're going to talk about what is it. We're going to go over a little bit of background regarding how we got where we are today. Talk about some relevant laws, um, talk about how you review your policies regarding pay decisions, how you audit your recent pay decisions, how to take corrective action, responding to challenges. That is, if someone challenges you that you are paying them unfairly. Pay equity is a method of eliminating gender and race discrimination when you're establishing and maintaining your wages. When we talk about establishing, that's creating your pay ranges, and maintaining it is when you're hiring and promoting people, and also on the merit increase side also. Just to give you a little bit of background, in 2021, full-time female employees earned 82% of what full-time male employees earned, and that is according to the U.S. Bureau of Labor Statistics. However, the gender gap has narrowed since 1979 because the statistic then was 62%, so it is much better now than it was. I think the pandemic has had a major impact on this um, um, percentage at this time because a lot of women have left their jobs in order to stay home right now. And there are some webinars that we have coming up that are going to talk about exactly what pandemic has done to the workforce. There are similar gaps that exist in the earnings of full-time minority workers when they're compared to non-minority workers. So we know we have some pay discrepancies out there. This has been around forever, and but it is getting better because employers are aware of it now, and there are laws that are being created to get employers to pay attention to it. The Equal Pay Act and Title VII of 1964, I'm sorry, Title VII, both prohibit discrimination in pay based on gender. So there are a couple of laws out there that are based on gender when it comes to being discriminatory in pay and other policies. Civil rights advocates cite the gender wage gap as compelling. I can't talk this afternoon. Compelling evidence of overpaid discrimination against female employees. But these are the civil rights advocates, and what we've found is that not necessarily true. Research indicates that a very small portion of this wage gap is attributable to paying women less than men for doing the same work. When I mentioned the 82% and the 62%, that's looking at all jobs that are out there compared to women versus men. The differential happens to occur because women are working in lower paying jobs. So it's really not fair to say that 82% of women are making less, but it could be specific to an industry or just because women are normally working in those lower paying jobs. Researchers agree that the male-female occupational patterns cause the largest portion of the gender pay gap. So let's talk about some relevant laws that apply to discrimination when it comes to pay. There are 4 federal statutes that ban discrimination in pay. There's the Equal Pay Act of 1964, the Title VII of the 1964 Civil Rights Act, the ADEA, and the ADA, Americans with Disabilities Act. Each one of those addresses discrimination in pay. The focus is extremely narrow under the Equal Pay Act. It only applies to gender. So if you have a claim that you're being paid less because you're older or you're disabled, it would not fall under the Equal Pay Act. Only deals with gender. It prohibits the employer from paying women less than men for doing the same or substantially the same work at the same facility. Because you may have, if you have an organization or a company in North Carolina, or you have one in California, you're going to pay differently in those locations because of the demographics and the costs of living. So this does look at the same facility, within the same facility. Under this act, the employee does not have to prove that the employer intended to discriminate. They need only to demonstrate that the employer pays men more than women. And we are talking about the same or substantially the same work. So under the Equal Pay Act, to avoid having a liability, the employer needs to prove that they have an affirmative defense. And that would be that the pay disparity is justified by a seniority system that rewards employees based on length of employment, because the longer you're there, the more you make. Sometimes that creates a problem where people have been there 25 years and they're making more than others in other departments that might be at the same level. But if there's a seniority system in place that rewards employees each year, merit increases, et cetera, then that's fine. That is an affirmative defense. Also, if you have a merit system that rewards employees for job performance, if one person is doing a better job than the other, the one that's doing the better job happens to be a male, then it is fine to pay that person more. That is considered an affirmative defense. Also, if you have an incentive system that pays employees based on the quality or quantity of their work performed, if the man is producing more widgets than the female employee, then it's fine to pay them more. Or any other factor related to job performance, business operations, like a shift differential. So I suppose if you have a woman working in the daytime doing the same job, but there's a man that works at night doing the same job, you can pay the man more because of a shift differential. So those kinds of things are fine, and those are called affirmative defenses. Claims under this act, though, are rare. And so this is probably not something that it will be very detrimental to your organization. The Civil Rights Act and Title VII of that act, it's a comprehensive federal law that prohibits discrimination in all aspects of employment, including compensation. Compensation discrimination in violation of Title VII can be established even if no member of the opposite sex holds an equal, higher paying job. So it's a little trickier than the first law that we looked at. Comparisons can actually be made between compensation of similarly situated employees. So it does have a more relaxed standard than under the Equal Pay Act. And then under Age Discrimination in Employment Act, the ADEA, this prohibits discrimination in pay against workers on the basis of age. It does use Title VII's standards of discrimination, so it's fairly liberal. And then the ADA, the Americans with Disabilities Act. If someone has a disability, you cannot discriminate against them, and it also uses Title VII standards. So those are the 4 laws at a federal level that would impact or result in some sort of a claim. If someone wanted to sue you, they would use one of these 4 laws. Right now, there is in the House a bill called the Paycheck Fairness Act. It passed in April. It passed the House in April of 2021, but this has been introduced several times, the same act, and so we're not sure if it is going to be something that we need to be more concerned about. The current administration is very focused on pay equity right now, and that being a priority, and one of the things that will be addressed in the next 3 years, 3 to 4 years. So this act would require employers to prove pay disparities are job-related and among other provisions. It amends the equal pay provisions of the Fair Labor Standards Act and requires the OFCCP to collect compensation data from federal contractors and evaluate pay practices of non-construction contractors annually. So this right now, if this does pass, it will only impact federal contractors. Once something impacts federal contractors, it usually does trickle down in many cases to other employers, general employers. But we have a lot of federal contractors that we do payroll for, and it doesn't matter, or you could be a subcontractor for a federal contractor and still be covered by this law. So the Biden administration does consider this pay equity a priority. President Biden has created a White House Gender Policy Council, and they're tasked with advancing gender equality in policy that is created, and it will be addressed by federal policies and programs. The one thing that is indicative of this act is that they have been promised, the agencies have been promised additional funding so that they can actually go after this and make it happen. The EEOC, the Department of Labor, the Federal Contract Compliance Programs, and the Justice Department's Civil Rights Division. So it has some weight behind it. And I think that this year, we've been talking about pay equity for the last 5 years, but this is the year that I think we may see something happen to laws that are generated that may have us taking a look at this. The EEOC has already added pay or compensation to the annual EEO 1 reporting. They did draw it back last year because of the pandemic, but it may come back up to be addressed later on. The EEO 1 report is filed by any employer that has over 100 employees. So this means that from a reporting standpoint, once the reports are in, there could be more legislation based on the results of those reports. I think the one thing too that we need to be more aware of than even the federal laws are the state laws, because the states are starting to make a lot of laws or create a lot of laws before the federal government does. Many states have already passed laws regarding discrimination in employment based on a wide variety of protected categories, not just gender, but other categories. And many of them have greater protections than the federal laws ever have. So the growing trends in pay equity are that we'll have more laws that prohibit asking about, number one, the job candidate's prior salary history. These are called ban the box rules, and 36 states already have these laws in place. This means that on an application for employment, you cannot ask for a candidate's prior salary history. What did you make in your last job? Because there are concerns that this practice perpetuates the gender-based salary gap. If someone earned a woman earned a lower amount in a job, and they're hired at a lower rate, because a lot of companies have a tendency to do this. Whatever you made in your last job, they base your new rate at their company on that. And that's really the wrong way to go about things, simply because they may have been paid less than they were worth or valued. Anyway, 36 states and 150 cities have passed this legislation, and this is going to be a trend in 2021 and 22. And check your applications. If you're in a state that has this law, then you need to make sure you don't have that on your application because it's illegal. California and Colorado have taken the lead on this and are implementing new pay equity laws that take effect in 2021. California, and this means not just California employers. If you have any employers in California, you have to comply with this for those employees. There's a pay data report came out under Senate Bill 973, a pay data report that requires employers to submit the data by sex, race, and ethnicity. It's very similar to the EEO-1 reports. The first reports have already been due, or if you don't have it in now, it's past due. We're due on March the 31st of this year. And in Colorado, they have a law now called the Equal Pay Transparency Rules. This requires employers to provide transparency related to employee pay and promotional opportunities. So when you advertise a job in Colorado, you have to put in the pay range. And I just read something this week where there are some employers that aren't advertising their jobs in Colorado for virtual positions because of that. They don't want to share employee pay rates. This took effect on January 1 of this year, so it's already in play. Obviously, I've gone through these first ones. Several other states have introduced legislation concerning pay disclosure requirements. Indiana, South Carolina, which I'm really surprised at, Massachusetts and Connecticut have some legislation that deals with disclosure of pay. If you're in one of those states and you want help determining what those laws are, let me know and I will help you do some research on that. Just as a reminder, as a pay entry client, you do have access to HR services for brief amounts of time, like phone calls and emails that we would pull a form for you or give you a policy on something or give you an answer to a question that you have about something like this. And that comes with your subscription to pay entry. Okay, so what are employers supposed to do to make sure that they're in compliance? Well, first of all, you need to conduct an audit. You need to, and there's a way to conduct an audit that will be safer for you. If someone came in right now and complained about the fact that you're paying a female less than you are a male in the same position, same length of service, same, performance levels, an audit that you do is not protected. It actually can be disclosed in court. But if you do the audit ahead of time, ahead of a court case, then you can keep it out of the courts. So some companies like to be prepared and go ahead and address it right now, and there's a way to do that. So number one, ensure confidentiality, review your pay structures, review your starting pay policies and your merit increase guidelines. What do you have as promotional pay as far as a policy goes? And how do you keep records? So before you start doing an audit, put confidentiality protections in place. And this would not, and this reminds you that unless the company is conducting the self-audit in anticipation of a court case, the audit's subject to discovery by the government. I think I got that backwards just a minute ago. If you're conducting the self-audit, it is not admissible in court. The audit is subject to discovery by the government if you're not doing it. I think I got that right. Unless the company is conducting the self-audit in anticipation of a court case, the audit will be subject to discovery by the government and the plaintiff's counsels, because once you have a discrimination case, it could be addressed from several different agencies. The EEOC could be involved if it's gender or race. If it's one of the other agencies would be involved in an age audit or what am I trying to say? Not a handicap or a type of disability discrimination. So you may have more than one agency involved. There are various approaches to maintaining an attorney-client privilege if you want this to be kept out of court. There's a common technique that involves having your president state in writing to counsel that they want to obtain legal advice concerning possible exposure to these discrimination claims. The communication would then again direct the counsel to use an appropriate individuals within the organization to conduct a voluntary self-audit of the practices, and then the CEO in that letter should state that all persons involved should treat the audit as confidential, mark all documents as privileged and confidential, prepared under direction of counsel. So if you do it advising your attorneys that you're going to be doing this, then there becomes an attorney-client privilege. So how do you go about reviewing your pay structure? Pay structure is looking at your pay rates for different jobs within an organization. Some companies have formal pay structures where they have ranges and people are in different grade levels. Other companies just hire based on market pricing. So you may not have a formal pay structure, but you're going to have to create something that shows how you pay for different jobs within an organization. So it's basically documenting that what your practices are. Then you would look at the 3 most common pay practices, which is your hiring rate or your starting pay. How do you handle merit increases? How do you handle promotion increases? So when you start to review your starting pay policies, your highest risk or challenge really does exist with the starting pay. And sometimes that boils down to, in 5 years, that person is still making less than the people they were hired at the same time. So this is where your highest risk is, because management usually has a lot of discretion in the hiring rate. And some companies have more than others. Some companies use a pay grade system where the hiring rate is established, and a manager can go no higher than a certain point in the range to hire. This is the best situation because if you don't have that, your managers have a lot of discretion in making that hiring rate. So controlling what managers are doing when they're hiring, what the hiring rate is, and what checks and balances are in place for control. If you have managers that just hire at the pay rate that they want to, then you're going to have some problems, because they need to have some rules in place to not evaluate but to control the level of discretion there is in that hiring rate decision. And then you review your starting pay policies. I'm sorry, this one is, we just had this last sentence. Can you explain and defend job offers that are not in line with the standard policy? So could you, if you had to go to court and you have 4 people that have been hired, and the woman or the female in the job is being paid less, they all started on the same day, how would you defend that? Do you have a structure in place? Your merit pay increase policies are also very important. Do you have a written policy regarding merit increases? Do you have any tools that you use or techniques to link performance to pay increases? Do you have a performance appraisal system that has a rating scale? And does that tie back to a merit matrix or something of that nature, or levels of pay? Are there other ways that you recognize performance also in addition to merit pay, like bonuses? And how much discretion does the manager have in determining the increase? I know I've been in HR for longer than I want to admit, but all managers think that everyone in their department is great and they want to give them the maximum raise. Well, in the real world, you can't do that. You have budgets. So when you're giving a manager a budget, how much control do you really have? Do they stay within their budget? Do they, or are they given a leeway to make changes to that? And do you use a merit increase matrix? If you don't, you should. That's a class, probably a webinar we need to teach, but it does give you the way to look at people and say where they are in their pay range and what their level of performance is. And it gives you a way to make sure that the percentage of increase that they're getting from merit is in line with their seniority, where they are in their pay scale, and their performance level. And again, what tools are in place to control management discretion and monitor compliance with written policies, because I've worked in companies where we would make a statement that the budget for your department is X, and it would not come back at X, it would come back at Y, which was much higher than the budget allowed. So monitoring compliance with written policies and being able to make sure that management is trained on those policies is very important. And so you need to be able also to audit your recent pay decisions. Start with gathering data that's how you pay, basic data. So you need a list of employees, their hire date, their position, and what they're making. You can add a lot of other things, whether they're exempt or non-exempt, full-time, part-time, because you can't pay differently for certain positions if they are in a different, say, part-time role, if they have lower education level or require more training. There are a lot of ways that you can look at this, but if you get all this information pulled into a spreadsheet, you can really do a good analysis on where you stand on pay, your current pay. And I mentioned too, there is a copy of this this overview, this webinar, in the handout section of your screen. Again, we're back to gathering the data. You want to look at recent merit increases, and you want to know how long that person's been in their job, what their performance ratings are, the dates on their merit increases, and what percentage they got. So this is another block of data that you need to add and collect. And then you need to look at recent promotional increases. What have you done as far as increases, let's just say over the last 2 years? You want to look at the date that the person was in their other job, the date and the rating of their last appraisal, the effective date of the promotion. All information on the new position should be gathered too, the department pay grade, all of those things, so that, and especially the promotion increase. What did they get from when they moved from one job up the ladder to the other? Now, all of this is being gathered together so you can really sit down and analyze how you're paying people. So in analyzing the data, if your initial analysis reveals a problem, then examine the data one layer at a time. Break it out by department, break it out by position, and dig deeper. And then determine if you need more information, because you may need to go back to the files and look for, reasons for certain things happening that are not in black and white in your computer from a data perspective. Once you analyze the data, you find where you have issues, you're going to want to revise your policies. One of the things you want to do is, if you don't have control over the manager's hiring and increase opportunities and limits, then you need to create a policy on what the rules are. And this would reduce manager discretion. Doesn't make the managers very happy, but it is a way to control. And I'm not saying that HR has to approve every single raise, but you have some policies and procedures that say, this is our hiring range, this is our hiring rate, and you can deviate up X percentage, but not down. And if some on merit increases, if you have a tool in place that guides them in what percentage to give someone with good performance or very good performance versus poor performance, then they will have the tools that they need to still have a little discretion on their end, but not total discretion. You need to improve your monitoring of your compliance with the pay equity laws and enhance documentation of your decisions. So, you know, in the HR, we always say two things: be consistent with whatever you're doing, and document. Write it down, collect the data, make sure that it's in writing somewhere. Employees can, I was going to talk about how you would find out if you were given a claim. You know, employees can file a discrimination charge with the EEOC. They can get an attorney who may do that for them. They can also, if it is an age discrimination, they could file it directly with the ADEA. ADEA, and then the ADA if there's a disability. But normally it starts out with the EEOC, and because that covers a broad range of situations. So if you ever get a claim, if you ever get a charge from the EEOC or an attorney through ADA and ADEA, make sure that you don't ignore it. Don't let it sit. You need to respond to those charges promptly, thoroughly, and effectively. They don't always need an attorney to handle them. If someone is trained in human resources, the EEOC charges are pretty straightforward, and there are ways that you can just present your information without spending a ton of money on an attorney, but it's never wrong to have an attorney involved in one of these things. If it is available, always use an alternative dispute resolution technique that's available through the EEOC and other agencies because it will be a lot less expensive in some cases. So, but one thing, if you ever get a charge, don't ignore it. Deal with it immediately because you can wait until the deadline is passed by accident, and you do not want to do that because they will rule against you. So, what should employers be doing? Number one, first thing, conduct an audit. Look at what you're doing right now and what you've done in the last 2 to 3 years. Review all your data and determine where your problems are. Then make changes. That's the biggest part. If you get to the review results and you don't make any changes and you have problems, that's not a good thing, because the agency, if they're able to capture this data that you have come up with, they're going to look at it like you knew and you didn't do anything about it. You need to update your compensation policies. If you don't have any compensation policies, you need to create them. With a hiring structure, merit increases, how they work, how does promotion to another job work, those kinds of policies. And bottom line, last but not least, train your managers and supervisors. If you know how to do it, but they don't, and they don't know the rules, then your program is going to fall flat on its face, because if they don't know the rules, they can't follow them. And unless you train them, it's not going to happen. You know, you can hand employees something to read, and same with managers and supervisors. Yes, here are the new policies. Read these and use them. That doesn't work well. You need some training in place to deal with it. Okay, there's a questions well, let's see. I think there's a questions box on your screen. And if you have any questions, I'm going to pull this little box over here and see if I can um, answer them. Okay, here's a question. Where would we submit the pay data report for sex, race, ethnicity for California? Megan, I will send you some information on that so you know specifically where to do that. And this would be for anyone who has any employees in California. Okay, any other questions? This is a very, it's kind of a dry subject because we're talking about laws and we're talking about auditing your data, but the bottom line is you just need to know what's going on in your company, what is happening, and are there any problems? Even if the EEOC never comes in to question your information, you might have an unhappy employee that you'll lose because they know that they're being paid less than someone working right beside them. Now, if the performance is different, that's something that you can deal with. But if you have a male and a female working in the same department doing the same thing, then they need to be paid equally based on your current compensation policies. Any other questions? Okay. Well, we'll end today's session by me just letting you know that we can help you with your day-to-day HR needs at HR Services. You will answer your questions. We also have programs in place, our new compliance package. We've had a lot of companies join our HR services department so that we can help them become compliant. We do work on this type of thing too. So if you need some help looking at it, we work on a project basis, we work on a virtual HR basis, and a lot of different ways that we can work with you, but we would love to help you. And so just let us know if you need any assistance with this. Okay, I think with that said, our next session coming up next Thursday is going to be on HIPAA in the workplace. And so we hope to see you then. And I hope you have a great afternoon. Thanks for attending.